rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. We're here for oral argument in our case number CV24-0190. Please keep in mind we're recording and live streaming the argument, so please identify yourselves and your clients at the beginning of your argument. Each side will have 20 minutes, but you're not obligated to use all that time. So please watch the clock and reserve counsel for appellant. Preserve as much time as you would like for rebuttal. Also keep in mind we've read the brief, we've studied the record, and have discussed the case in conference. With that, counsel for appellant, you may proceed.
Thank you, Your Honor. Craig Steffen appearing on behalf of Artemis SHAMAMIAN and the Adrena SHAMAMIAN Living Trust. I would like to reserve 5 minutes for rebuttal, Your Honor. As you know, the issues in this case involve the statute of limitations. The trial judge granted summary judgment on the statute of limitations against Davis Miles. Well, Davis Miles, McGuire, and Gardner, I'll refer to them as Davis Miles. I think it's important at the outset to understand plaintiff's theory of the case.
If I could just interrupt for a moment. There's no dispute that the longest limitation statute is 3 years, right? They're all 3 years or less.
Right, that's correct.
All right, thank you.
Yes. As I said, I think it's important to understand the theory of plaintiff's case. And I laid this out, I think, most easily and simply in my reply brief, actually. And that is that plaintiff's theory is that SHAMAMIAN would not have retained Pashonic and Davis Miles if she had known Pashonic was not licensed in the state of Arizona. She would, and that's the first theory. Under that theory, at the point of engagement, which occurred on or around March 30th of 2015, liability attached immediately because SHAMAMIAN was never told or informed that Pashonic was not licensed in Arizona. So in our theory is that once SHAMAMIAN began paying fees to somebody she never would have retained, those fees were paid, all those fees basically become damages, because but for the failure to disclose that Pashonic was not licensed in Arizona, she never would have incurred a fee, a penny. And as you know, she incurred over $422,000 in fees over about a 6-year period. The second key time frame is the termination.
Let me ask you a question on the first one.
Yes, sure.
Is there a point in time where she realized he was not licensed in Arizona?
No, there wasn't. In fact, there's nothing in the record that indicates that she was not licensed in Arizona. I'll just tell you that, before I took this case, when I was reviewing, SHAMAMIAN has what I would just refer to as a ton of records, okay? She keeps almost everything. I had to go through all of those records because I wanted to satisfy myself and the client that there's nothing in there, like an email or a text or something that says, recognizes that he was not licensed in Arizona. Because
for the work that was being done, did he need to be licensed in Arizona?
I believe he did need to be licensed in Arizona, and I don't believe that backdooring the client by questioning whether he had to be licensed in Arizona is the issue. I think the issue is whether or not the client would have in the first place retained this lawyer, because that's the decision of the client. the client doesn't have to have another lawyer to explain to her why she needs this lawyer. She didn't understand fully all of the legal issues that were going to present themselves. But she did know one thing. She wanted an Arizona lawyer. Her mother had an Arizona trust. She believed that she needed an Arizona lawyer to deal with that Arizona trust. And there were other issues. I think I've laid them out in my briefing here. Other reasons that she wanted an Arizona lawyer. Now,
One
Yes.
can always find out who's licensed in Arizona by going to the State Bar's website. So what is the significance of that, the fact that there was information available from other sources?
well, the significance of that is that it's not significant. It's irrelevant. And it's irrelevant.
Counsel, if it was so important, how is it irrelevant? If it was so important to her that that he be licensed in Arizona, it seems like you're coming at it from both sides there.
No, I'm not, because under the law, and the trial judge agreed with us, that Pashonic was an apparent agent of Davis Miles. Understood. And once Pashonic entered the agreement with my client, SHAMAMIAN, an attorney-client relationship was established between, on the one hand, Pashonic and Davis Miles, and on the other hand, my clients. Once that attaches, there are fiduciary duties that apply, and the attorney side.
Did the firms, either one, did the firms hold themselves out? Did they represent specifically that he was licensed to practice in Arizona?
Yes, they did. They didn't specifically say he's licensed to practice in Arizona. However, under the ethical rules, 5.5F and 5.5B2, B2 talks about holding out oneself, being an unlicensed lawyer, holding oneself out in Arizona as an Arizona lawyer. And the concept of holding out is a concept that is broadly appears throughout professionals malpractice. And I've handled cases involving professionals malpractice for about 40 years. And in virtually every complaint that I write and every complaint I've seen, there's a sentence that says so-and-so held himself out, or a firm held this person out as either a physician, dentist, attorney, or what have you. So this concept of holding out is something that's widely known in the law, and it's incorporated into the ethical rules. And when the ethical rules can establish a standard of conduct for lawyers, the ethical rules are essentially based upon the concept of fiduciary duty.
But at some point, she knew or should have known that Mr. Pashonic was no longer with Davis Miles, right?
At some point, she should have known that.
And what do you think the record shows that point to be?
I don't think well, I believe that she did not know that until 2021. However, that's a jury question as to when that occurred. That's not a question for the court, because I think in the court's ruling, the court actually said that no later than the end of 2016, she should have known that that Pashonic was no longer with Davis Miles. I don't think that's accurate. I mean, it's possible that someone would believe that, but it's also quite possible that someone would believe at some later date, perhaps she knew. And that is a jury question. It's not a question that the trial court can answer for the jury, which I think is what happened here.
Well, there's evidence in the record that in August of 2015, she sent a draft of a demand letter or some kind of letter to Mr. Pashonic for his review and edit. The letter identified Mr. Pashonic as care of Davis Miles, and he told her, no, change that to care of the
Gonzalez-Saggio
yes.
firm, right?
Why doesn't that put her at least on inquiry notice that he's no longer with Davis Miles, he's with a different firm?
Well, because everything continued for her as it had been proceeding. Pashonic continued to use he told her at one point to use his address. He didn't say it. She never knew it was his home address. He just gave her a mailing address, and he said to use his email address and phone number. And as she testified in deposition, and there were lengthy depositions in this case, she testified that she believed that that was a good thing, that Pashonic was actually singling her out to give her personalized treatment instead of having to go through the firm. And as she testified, the engagement letter to her was sacrosanct. Those are her words. The engagement letter was sacrosanct, and everything proceeded according to the engagement letter as far as she knew. She was never told otherwise.
So, counsel,
Yeah,
I
sure.
just want to make sure I'm tracking.
Yeah.
So the engagement letter references Davis Miles, but all of the billing statements, emails she's sending, payments she's making, none of it is going to Davis Miles. It's going to Pashonic. Is that correct?
All the payments went to
And all
Pashonic,
the-
yes.
Okay, and the email communication is not Davis Miles' email, it's Pashonic's Gmail account, or?
Well, she made the payments exactly as instructed the entire time, as instructed in the engagement letter.
Okay, and so I'm not trying to trap you or
Yeah,
anything, I'm just
right.
trying to make sure I'm tracking.
Right.
And then in 2015, this letter that Judge Kiley's referenced, that she sends to Pashonic, and Pashonic edits it and says, no, not Davis Miles, Gonzalez, whatever. So at that point, what is it reasonable for, would a rational trier of fact conclude that your client could believe that Pashonic's still associated with Davis Miles? I know
Well,
you're
let me
saying
answer
fact-
that
I know
question.
you're saying
That's a
fact
good question, Judge. Yeah, I understand, and that's a key question. And the answer to that question is yes, a rational trier of fact could believe that. However, you have to weigh and balance the evidence, not just from Davis Miles, but the evidence and testimony from SHAMAMIAN. And so a rational trier of fact could also believe that she didn't think at that point in time that Pashonic was with a law firm because the billings kept coming to her the same way they had come originally. The first billing came to her, and they all actually came to her in some form of Pashonic and Kruliski, with a tagline at the top saying, identifying Pashonic as of counsel. We're dealing here with a layperson, so she thought of counsel meant the same thing it meant when she got emails through Pashonic on the Davis Miles letterhead that he was of counsel. She thought that meant he was an attorney with Davis Miles. That's her testimony. She then also, when those billings began coming, the first billing said Pashonic and Kruliski affiliated with Davis Miles. That last portion, tagline, was left off the subsequent billing statements. But there's certainly evidence in this case from which, as you suggest, on the one hand, a juror could say, this lady should have known by the end, as the judge said, by the end of 2016. Somebody could say equally reasonably that that's not the case. That believing her testimony, and I believe my witness is a very credible witness, that believing her testimony, that's not the case. Because her testimony is that she never knew that he had left. And there's additional evidence in the record that Davis Miles themselves had access to all of Pashonic's emails. But they never, on a server in their own office. They archived those emails according to the COO, Jackie McCafferty, but apparently nobody looked at them.
Well, I thought the emails were on Mr. Pashonic's Gmail account.
No, they were not. That's incorrect. Those emails were all on a server in the offices of Davis Miles that was operated by their IT people. They had, I think, 2 IT people there.
For how long? What time period?
During the period of time that certainly that that Pashonic was at Davis Miles, and I don't think today that's the case, but that server is still there, and I know that because general counsel for Davis Miles went back in October of 2022, after the case had been going for over a year, and they went into that server and they pulled out the emails. And the emails show there's a copy of the engagement letter, a copy of the signature page that the client emailed to Davis Miles, a copy of her mother's trust, and long story short, they had her email address, phone number. They could have easily contacted her, but they never did.
The termination, Mr. Pashanik's termination or separation from Davis Miles was in June of 2015. Are there any emails between Mr. Pashanik and your client after that date, after June of 2015?
Yes, there's a lot of emails. They're voluminous emails.
On the Davis Miles,
Pardon me?
on the Davis Miles email account?
On the day, it's hard for me to answer that. I know that I think there were contacts relating to Davis Miles all the way into 2016, but I'm not going to sit here and make a representation of that, but I do believe there were things beyond that date. So that, I believe that am I getting into my time? Is this 4:42? Is that what I've got left?
Right. It's up to you.
Okay. So I believe essentially in this case that the judge got it wrong. And if you look at the judge's ruling, the judge says in the ruling, if I can get this correctly here, he basically...
Here's what I found.
Oh, gosh. Okay.
Siri here. Let me know if I can help.
Yeah. The judge says in paragraph 13 of his ruling, in Watt, there were 4 conditions that were present that entitled patient to avail herself of fraudulent concealment rule. A, existence of a fiduciary duty. B, the defendant's actual knowledge of his negligence. C, the defendant's actual knowledge of the identity of the aggrieved party. And D, the defendant's decision when faced with the negligence to not make a disclosure to the aggrieved party in that case. That's an incorrect evaluation. What the trial judge did was he went into this case that I gave him, which is Walk versus Ring, and he went into the facts of that case, and he pulled a rule out based on the facts in that particular case. And that's an incorrect way to, ruling. It's an incorrect analysis, because that's not an analysis done by the Arizona Supreme Court. The Arizona Supreme Court made it clear that they were talking about fiduciary duties, situations where there were fiduciary duties. And as the Lasley versus Helms case sets out, fiduciary duty, breach of fiduciary duty, and fraudulent concealment basically is based on fraudulent concealment is essentially based on constructive fraud. That's a breach of fiduciary duty that tends to mislead somebody. In this case, the attorneys, by holding this unlicensed lawyer out to this client, were making a misrepresentation of a material fact to this client. The misrepresentation being that this guy's an Arizona lawyer. And certainly this client, as would any client under these circumstances, had the right to believe that this was an Arizona lawyer. He's operating out of an Arizona law firm, has his own office, meets her in the conference room, has a telephone, has an email, etc. So she reasonably believed he was an Arizona lawyer, and in making that misrepresentation, they are basically, that is fraudulent concealment. And they are leading the client to believe something. The client has the right to rely on their representations because they're fiduciaries. And in having the right to rely on that, the client does not have to go to the State Bar of Arizona and look it up, doesn't have to go to a lawyer and say, is this guy really licensed? Doesn't have to do any of that, because the client is entitled to rely on the lawyer. And that is exactly what happened in this case. So that is fraudulent concealment, and that also tolls the statute of limitations. But I wanted to just flip back here. I'll have 1 minute left here in a few seconds. I just want to flip back to my legal theory regarding the engagement. And that is that this client was never informed that Peshonic was not licensed in Arizona. That tolls the statute of limitations under the discovery rule until there's evidence that he was in fact licensed. And there's no such evidence in the case. So under the discovery rule alone, I believe our case survives, but certainly when you also apply the fraudulent concealment rule, where the requirement is that actual knowledge be acquired in order to trigger the running of the statute, no such actual knowledge was ever acquired by this client. I'll give it up here. I'll have 10 seconds left or something. Thank you, Your Honor.
Counsel.
Good morning. May it please the court. Thomas Crouch on behalf of Davis Miles and the individual managers who technically only one of them is an appellee in this matter. The dismissal of the other three wasn't appealed. To answer the question, no, the record doesn't contain any email communications through the davismiles.com @davismiles.com email address after Mr. Pashnik, I may be pronouncing it incorrect, instructed SHAMAMIAN to communicate with him through his personal email, Gmail address.
Did the Davis Miles website have a bio on Peshonic?
At the time he was
in February 2015 or March 2015.
at the time the of counsel agreement was in effect, yes.
Was there anything on the website that indicated either where he was licensed to practice law?
Yes, and that's in the record. It very clearly stated he was a member of the State Bar of Michigan, and that he was licensed to practice in the state and federal courts of Michigan. It did not represent that he was licensed or admitted in Arizona.
Do you know where in the record that is? If you don't, it's okay.
I can tell you this, I don't have it memorized, but if you find that statement in my brief, I guarantee there's a citation to it, to the specific page.
Does the record show anything about whether Davis Miles took any steps to notify Mr. Peshonik's clients that he was no longer associated with the firm?
The record is undisputed that no one at the firm knew of Ms. SHAMAMIAN. As far as there wasn't an effort to develop any record on notice to anybody else. And if I can provide some background on the of counsel agreement, this was a situation where they could voluntarily essentially enlist the assistance of each other. The firm could enlist Mr. Pashnik or Kruliski to assist on firm client matters and vice versa.
But Davis Miles didn't have a copy of the retainer agreement with Ms. SHAMAMIAN?
No one knew of that. I believe their server, and what we're talking about when we're saying their servers is what at davismiles.com emails are on their server. And that server did contain the retainer agreement on Davis Miles' letterhead. Nobody knew about it. A file wasn't opened. The evidence is also undisputed that a file was not opened in their system. No conflicts check was run. Nobody had any communication or contact with Ms. SHAMAMIAN other than a receptionist who set up an initial meeting at their offices. But the record is also clear that after the termination of the agreement in June, there's no further communications through a Davis Miles phone line, through an at davismiles.com email address, any meetings there, and she's instructed by Mr. Pashnik communicate through my cell phone and my Gmail address. All invoices thereafter. There's only one invoice, and it's the one for time period when he's of counsel that refers to and says affiliated with, Mr. Pashnik affiliated with Davis Miles. All the invoices thereafter are either, and it's at the top of the invoice, and these are in the record, either Pashnik and Kruliski PC or just Pashnik and Kruliski. And I was going to go through some of these. I think from the questioning, it's clear that the court is aware of probably what my fire was going to be in this oral argument, and I was going to focus on that August letter that she drafts, and if I can point to one specific piece of the record, go review her deposition, page 1 of 22, lines 2 through 7. And
what page? What?
Page 122
Okay.
of SHAMAMIAN's deposition,
Okay.
lines 2 through 7. And this is referencing that Gonzalez firm, so she made the change herself, and she concedes in that testimony she knew that she knew of this other firm. And she's asked, well, did you ask about it? No, didn't ask about that other firm. So I from listening to the argument this morning, I think one principle I can add to this argument is every fact can be determined as a matter of law. And that's what summary judgment's there for. It's for the parties to put forth their evidence on any given fact. And if the evidence is conclusive, that's what summary judgment's for. That's what occurred here today.
Is this the portion of the transcript you're referring to? Question. Did you ask him who the Gonzalez Saggio Harlan law firm were? Answer, I don't recall. Question, did you see that he had made the change to Gonzalez Saggio Harlan? Answer, yes. Is that the portion you're referring to?
Yes, Your Honor. So,
But even with the facts, even with the letter, even with the change of the law firm noted, and even with that deposition testimony, still, what's wrong with the opposing counsel's argument that these are still, I mean, you're still in an area where it's arguably a question of fact for the jury. Why not let this go forward to a jury?
I think the missing element here was he was focusing on the knowledge component of our law on when statute of limitations begins to run. And it isn't what did you know, it's what did you have reason to know. And all of the evidence in this case is conclusive.
You're saying inquiry. At what point do you have to inquire? Is that what you're saying?
That's
Put you on notice to do something about it.
Yeah, I think any court at looking at a statute of limitations issue or argument does two things. One, what are the acts, by the defendant against whom the claim is brought? I think we both described them the same way in our briefing in an argument this morning. This is about the firm allegedly holding him out as its Arizona lawyer, and she paid attorney fees to this lawyer, and she's not happy for the fees she paid over the next 4 years, and she wants those fees from my client. Okay, well, when did she have knowledge of that? And keep in mind, two theories. One is the acts of Davis Miles in holding him out as its lawyer, and she wanted the muscle of a firm, and representing, even though the record's clear that they didn't represent, but representing that he was an Arizona attorney. And the other theory is vicarious liability. We didn't hear much about that today, but that's the other theory, is he was an ostensible agent or an apparent agent for all these years. Well, the Superior Court asks, when did she have reason to know that he wasn't affiliated with Davis Miles? And the record on that was absolutely clear.
What does the record show about what the work was that Mr. Pashanik did to receive $400,000?
The best thing I can tell you to do is all those invoices are are in the record, and you can read through them. Lots of phone communications with his client and with federal agencies, but that's the best I can tell you.
Did he need a license? Did he need an Arizona bar license to I know you're
I know
maybe
that's
going out on a
get-
limb there, but
yeah, that's moving on to the merits and beyond the statute of limitations. My answer would be no. I mean, there was nothing Arizona specific. The two properties at issue, and I would actually defer to my colleague on a better description of what the issues were with those properties, but one was in New Jersey and one was in California. Now, it's an Arizona trust. And there is record evidence explaining why Pashnik and Kruliski are kind of a pair, and Pashnik would rely upon Kruliski because he was licensed in Arizona. So if he had to file something, Kruliski would be counsel of record. I do want to just briefly remind the court, there's two kind of main issues here. One is the statute of limitations issue, which is dispositive of the entire appeal. An affirmance on that, I suppose, means you don't have to address the second issue. But the second issue was the dismissal of the individual, the managers, which the court said was an independent finding that they were entitled to summary judgment. Only the dismissal of the claims against Mr. McGuire were appealed. And I just want to finish with a quick note that the evidence is undisputed that none of the four had any knowledge of this representation, participated in any way. It's a limited liability company. There was simply no facts presented that would provide a basis for either concluding that Mr. Pashnik was an agent of any of the four individuals, or that they're exposed to personal liability by having done something themselves in connection with the representation. We ask for affirmance.
thank you, counsel.
Do you mind if I make a statement or two, Judge?
How about we give you 30 seconds to wrap up?
Okay, that's fine. What I want to say here is that in that ruling, the trial judge did not even address our theory of the case that the client never knew Pashnik was not licensed in Arizona. He never addressed that issue with respect to even the discovery rule. That's why I'm trying to tell you here today the discovery rule alone, I think, would save that part of the case. And with respect to Mr. McGuire, Pernell McGuire, who was the manager, we put in a lot of evidence about failure to vet Mr. Pashnik, failure to supervise Mr. Pashnik, et cetera. So that's in the record.
Okay.
Thank you.
Counsel, thank you both for your arguments. The court will take this matter under advisement and issue a decision in due course.
Thank you very much.